Hey everybody, welcome to Thursday night. John Skiba here with the Consumer Warrior YouTube channel, like we do each and every Thursday night to talk about all things debt related. I am an attorney in the state of Arizona, and I help people who are dealing with serious debt issues. And my whole point in this channel is to provide you with some resources and information and maybe point you in the right direction to be able to help you deal with things, whether it's, overwhelming credit card debt, wage garnishment, if you're facing bankruptcy, any of those types of things. That's the whole point, is to provide information on the channel. I do this live Q&A each and every Thursday night to talk about questions that you have and topics that you want to address. And if there is a question you have, go ahead and put it in the chat section if you're on YouTube, or in the comments on Facebook. I'll put it up on the screen and we can talk about it. My weekly disclaimer is, even though I'm a licensed attorney in the state of Arizona, I'm not licensed anywhere else. And so you got to just take this for what it is. It's some guy talking on YouTube, and it doesn't create any type of attorney-client relationship or any type of specific legal advice. If you need an attorney, I recommend you contact an attorney in your specific state. If you're in the state of Arizona, my number is scrolling across the screen. There's also a link below where you can actually click on there and set up an appointment. And you know what? I'll actually put that in the chat section. If you're in Arizona, I do free consults. You'll talk to me directly. I'll put that in the chat and you can set up an appointment and we can talk about it. Before we get started, I just want to say thank you to the wonderful sponsor each and every week that we have of SoloSuit. SoloSuit is a company that use technology and other tools to help people who are dealing with debt problems. SoloSuit does things like helps you answer debt collection lawsuits, debt settlement, motions to compel private arbitrations. The link there is at the top of the chat section. Go ahead and check them out. They're a great sponsor that helps out the channel, and they help you out as well. All right. So if you have some questions, go ahead and put them in the chat section. I had a number of questions and comments on the channel that I thought it would be good to address today. This one relates to Chapter 13 bankruptcy. Now, Chapter 13 bankruptcy is different than the typical bankruptcy of what most people think about. Most people file Chapter 7 bankruptcy. Chapter 7 bankruptcy is a relatively short process, takes about 4 to 5 months, which is smoking fast in federal court to do anything. It also gets rid of all your debt. You typically don't have to pay anything back, and it's just really what most people prefer. However, if you don't qualify for a Chapter 13 because your income is too high, or if there's other reasons like you're behind on your house payment, you need to get caught up, that kind of stuff, you can do a Chapter 13 case. Chapter 13 bankruptcy takes a long time. Most Chapter 13 bankruptcies are 5 years long. If I'm helping you out with the Chapter 13, we're going to become friends because we're going to hang out together for 5 years. I'm going to be an old guy by the time we get done with this case. But this question said, if my income is under the median annual income limit on the means test, am I eligible for a 3-year Chapter 13 instead of a 5 years? This person wants to know, is that true? So this is a great question. Let me tell you kind of how we determine how long your plan is going to be. Again, and if you, to file Chapter 7, that's the one that takes 4 months. You kind of get in, get out, get rid of the debt, that kind of thing. But you have to qualify for it. And there's a means test, and they take a look at your household size as far as the number of people that live in your home. They look at your income. And if you make more than the average family of your size in your state, you may have to file Chapter 13. However, there are certain reasons some people want to file Chapter 13. Like I mentioned, like if your house is heading into foreclosure. Here in Arizona, we're starting to see that a little more. It's been one of these things since 2000, since the whole COVID pandemic. There's always been this thought of there's going to be this just avalanche of bankruptcy filings, and there never has been, because the government's really done some stopgap measures that have kind of delayed things a bit. But it seems like it's starting to feel a little bit like 2008, 2010, that time frame. We're starting to see more people coming in with mortgage problems. So you can file a Chapter 13 bankruptcy, stop a foreclosure on your home, and take the amount that you're past due on your house and pay it out over a 5-year period. So if you're behind 10 grand in house payments, you can stop that foreclosure, take the 10 grand, divide it by 60 months, and get it caught up and kind of bring some structure to it. However, if your income is below the median, if you're eligible for a Chapter 7, but you still need to file a Chapter 13, then the answer to this question is yes. You can file a chapter, you can do a 3-year Chapter 13 bankruptcy and only be in there 36 months. And in fact, if your income is below the median, below the means test, and you're eligible for a Chapter 7, but you end up doing a 13 because of some of those other issues, it can actually be anywhere from 36 up to 60 months. So you have some flexibility there in ways to get that done. All right, this person said, when you file for bankruptcy, do you lose your stocks? I don't want to cash out as I'm saving for retirement. Also, do you lose your personal bank account? This is another good question. So when we're talking Chapter 7, Chapter 13 bankruptcy, Chapter 7 is, again, what most people file. So most people prefer because it's much longer. It gets rid of all that debt. You're not doing this big, long payment plan. However, the big picture idea is we're getting rid of all the debt, but they're going to look to see, are there any assets that can be sold for the benefit of your creditors? And if there are, they can, the bankruptcy court can seize the asset, sell it, and then make a distribution to your creditors. Now, most things in a bankruptcy are exempt. There's all these exemption laws, both in the federal and the states, that have these laws that protect your stuff. And it varies from state to state. And so that's why this question's a good one, but it's also one that you probably need to talk to an attorney in your particular state to determine if your property is exempt. So I'll tell you, like, for example, in Arizona, if you have just like a money market account with stocks, mutual fund, that kind of thing, those are not exempt in a Chapter 7 in the state of Arizona. You will lose them. 100% you'll lose them. And so that's one of the situations, if I have a client who has a bunch of stocks, it comes in, we look at ways, probably better sell the stocks and use those for general living expenses, file bankruptcy down the road, or alternatively, just know that you're going to lose the stocks when you file the case. Some people don't care, they might have $1,000 of whatever, and they'll say, we'll lose that through the bankruptcy just so I can get rid of all this debt. This also applies to cryptocurrency. Some people think that crypto, Bitcoin, things like that the creditors can't find them or the trustee can't find them. Not true. If you go look at a lot of the wallets, the digital wallets, Coinbase is one. I know they actually have a link on their website for bankruptcy trustees to fill out a form, and the wallet will provide information to the trustees so they can take your cryptocurrency. So typically not exempt there. Now, some states, Arizona does not, but some states have a wild card exemption, and this you can apply to anything. So, and it's usually somewhere between $3,000 and $5,000. There's an exemption in California, though, that can be considerably more based upon some technical things with the homestead, all this. So there may be an exemption that you could apply to it, even if there isn't something specific for stocks. Now, this person brings up a good point as it relates to retirement. Now, if the stocks are in a retirement account, let's say you have like an IRA, 401k, something like that, those are exempt under federal law and state law here in Arizona, and those will be protected. So that's where you need to talk to someone in your state specifically. Things like bank accounts in Arizona, in 2022, this thing called Prop 209 passed. I guess, they say elections have consequences. Well, this was a good consequence. Prop 209 passed, and it raised the exemption in a bank account in the state of Arizona to $5,000 in your bank account is protected, is exempt. And if you're married, you can double that. You can have $10,000 is protected in your account when you file. So that's a pretty huge thing. So, for example, if you had stocks, $10,000 worth of stock, that's not exempt, but you in Arizona, you can sell it, put the money in your checking account, and if you're married, you can protect up to $10,000. So exemptions are tricky. They're state by state. There's something you have to be very careful of, and something for sure if you're looking to file bankruptcy. And if you have assets, you need to, one, disclose them, and two, talk to the attorney about it specifically to make sure that you can get it exempted. So, all right, here's a question that said, I filed for Chapter 7. It was discharged. Would it be wise to negotiate with creditors to remove late payment records received prior to filing Chapter 7? Okay, good question. So, and this kind of leads to the bigger question of what does your credit report look like after you file a Chapter 7 bankruptcy? So you file the bankruptcy. The end goal of a bankruptcy is to get the discharge order from your judge. That's the final order signed by your judge. It says you no longer owe these debts. what your credit report will look like. As soon as you file it, usually about 30 days later, you're going to see there's a public records section of your credit report. It's going to say District of Arizona, Chapter 7, bankruptcy. And then once it's discharged, it'll say discharged. Now, as far as what your credit, the individual creditors, those lines, those will all stay there, but they will stop reporting any information on there. And once the discharge is entered, they will zero out the balance owed and it will put discharged in bankruptcy. So the question is, should you, and by the way, it stays on there for 10 years, on your credit report. It doesn't impact your credit score for 10 years. That's kind of a little side note. Even though it's on there for 10 years, most people's credit score fully recovers in about 18 to 24 months after the Chapter 7 is over. Like you can get FHA, VA, they'll do regular mortgage loans 2 years after a Chapter 7. Some lenders are 3. Car loans and credit cards, for good or for bad, they're available almost immediately. One thing that really surprises a lot of my clients is as soon as we file their case, within a week, their mailbox is full of car loan advertisements, credit card advertisements. Those are available. You're just going to have bad interest rates until you get a little bit further from it. So as far as this question here, should you go and negotiate with the creditors to remove late payment records? I would say no. The damage has already been done. I always say the Chapter 7 filing is throwing the grenade on this whole thing. You took the nuclear option already. Any damage is going to be done. Going in and getting lates removed off there. 1, they're not required to do it, and 2, it's not going to impact your credit overall. It also brings up a point. If you were to reach out and say you had an account with Wells Fargo or Chase Bank or something like that, a credit card, even if you're wanting to voluntarily pay them after your bankruptcy, they're not going to accept that. The reason why they're not going to accept that is because of that discharge order. The discharge order is the order from the judge that says these debts are legally gone. And so they don't want to run afoul of the discharge order because they could be sanctioned by the court. So they're not even going to accept it. So my recommendation would be to focus on, new things of, some people will get like a secured credit card or something to help build your credit. And frankly, just letting time pass by so that you can get further away from that filing date, from your discharge date. You're going to see that your credit will start to improve actually pretty quickly. Like I said, a lot more quickly than most people anticipate, rather than going back and trying to mess with those. So, all right. Looks like that's all the questions we have for today. We'll go a little bit shorter today. But again, if you have any questions, if you're in the state of Arizona, check out my information below, or check out Solo Suit. Again, great sponsors. They have some really cool products over there that help with responding to debt collection lawsuits, debt settlement, as well as some other tools with motions to compel arbitration and all that kind of stuff. So let's see here. Scott had a question. I've been to a few lawyers for consumer protection against an auto loan bank that had forced place insurance. That's my only negative in my report. What can I do? So if there's something on your credit report that's negative, that's not accurate, and that's the key. It's got to be not accurate. If it's not accurate, there's a law called the Fair Credit Reporting Act that allows consumers to not only raise objections, but you can actually file a lawsuit against both the creditor and the credit reporting agency, TransUnion, Equifax, Experian, those entities, to try to get it dealt with. Now, the FCRA, the Fair Credit Reporting Act, states that if you're going to file a lawsuit, there is a prerequisite. You got to raise an objection to it. My recommendation on this, you need to do that first before any other steps can be taken. Go to the websites of TransUnion, Equifax, Experian, wherever it's showing up, submit a dispute. The dispute process is done online, takes 30 days, and they will get back to you pretty quickly. Because what the credit reporting agency does is they take your dispute, they send it to the auto loan lender here and say, hey, this has been disputed. They have 30 days to respond to it. If they don't respond to it in 30 days, then by law, the credit reporting agency has to remove it completely. So that's what I would do. Again, and then the other issue, and then if they come back and say, no, it is accurate. Okay. Scott probably said it did, but it comes back verified. Really, then what you're left with is you're going to have to, if it's not accurate and they're not changing it, that's when you have to exercise your rights under the Fair Credit Reporting Act. It actually requires you to file a lawsuit to get that fixed. I don't do a lot of fair credit reporting litigation. There are attorneys. I don't know, Scott, if you want to put what state you're in the chat, I might be able to see if I could give you a referral. But it is one of the, it's an area where that's how you're going to get relief. If it's something where if they're just not working with you, they keep verifying it, even though it's not accurate, you're going to have to find a Fair Credit Reporting Act attorney. It says you're in Texas. Unfortunately, the attorneys I know, I have one in Arizona, Minnesota, a couple others. But just Google that, FCRA or Fair Credit Reporting attorney, and you'll find someone there in Texas. Texas is a gigantic state, and there's going to be people there who can help you out with that. So, all right, with that being said, I think we'll close it out for today. Hope you all have a great Labor Day weekend. We're getting ready to go into that Labor Day weekend. College football starting. There we go. BYU. I think we're playing Southern Illinois or somebody like that. I'm actually going up to the game. I'm taking my daughters up to the game, something that I haven't done. I'm embarrassed to say I played for BYU. A lot of you know that have followed the channel. I don't think all my daughters, I have 5 daughters, that they have actually gone to a game with me. So that's going to be fun. Oh, looks like there's one more question. We'll do that one. I have a past due American Express card, 9 months since the last payment, which I received a letter from Zwicker Law Firm requesting payment. Are you familiar with this firm? Oh, yeah, I'm familiar with Zwicker. So Zwicker and Associates, they do most of the collections for American Express. I'm going to tell you this. Of all the creditors, American Express, of the credit cards, they're the most aggressive. They do file suit usually within 12 to 18 months after the account goes into default. So if it's something where they're reaching out to you, American Express doesn't sell their debt either. So Zwicker's just a law firm. They're just the hired guns that are in there to prosecute the case. I would try to work out some type of settlement arrangement with them. They will file suit, particularly for that amount. You're looking at 13 grand. They will file suit and they'll negotiate. The one thing I do see with American Express is they will give you long payment plans. I mean, I negotiated a payment plan once, like 72 months on a credit card. It was a really low monthly amount. I would definitely reach out to them. So, all right. Rocky says, MCM, Midland Credit Management, sent me a couple collection letters on a 2-year-old city card debt. I reside in Washington State. They say, due to the age of the debt, we will not sue you. Can I hold them to that? Okay, so this is a good thing. So there's another law. We're doing all the acronym laws. So we have the Fair Credit Reporting Act. Now let's talk about the Fair Debt Collection Practices Act, the FDCPA. So the FDCPA states that if a debt is outside the time frame when the creditor can sue you, so that's the statute of limitations, they have to notify you in writing, even on the letter. So that's what you're seeing here. So the good thing is Midland Credit, they're following the FDCPA. They're saying, hey, that due to the age of this debt, they're not going to sue you. Can you hold them to that? Absolutely, you can hold them to that. Hang on to that letter. You should be so lucky that they should file a lawsuit against you because you'll then have an FDCPA claim. They're going to be writing you a check for at least $1,000 to cover the statutory damages on that. So they're acknowledging, I would scan that letter in, keep a copy of it. But they're acknowledging that they're not going to sue you. And typically, it's probably not even on your credit report anymore, would be my guess. I would say, that one's done, that you can move on from that one. All right. So it says, if the statute of limitations expired, can creditors still sue and collect? I think you and Rocky are working together on this because it's a good follow-up question to that. Statute of limitations, that's the amount of time that a creditor has to file its lawsuit. So there's 2 questions here. Can they sue? No. Well, I should say this. Can they sue? Yeah, they can sue, but you could win. You could get it thrown out. And if it's a junk debt buyer, like I was telling Rocky, you could sue them for not only, you could counterclaim them under the Fair Debt Collection Practices Act. So if the statute of limitations has expired, they can sue. They likely won't, but they could, and you could get it dismissed. Can they still collect? Yes. They can send you letters just like Rocky was receiving, saying, hey, we want you to voluntarily pay. They should be including that terminology on there that says, we can't sue you. It's outside the statute, but just want to voluntarily give us some money. It's going to be that kind of thing. So yes, they can still try to collect on them. And just as a refresher, if you're new to the channel, the statute of limitations is the amount of time from when the account goes into default that the law gives them to file a lawsuit against you. So for example, in Arizona, credit card debt has a 6-year statute of limitations. So it's roughly 30 some odd days after the last payment. They have 6 years to sue you. If they do file a lawsuit within that 6-year period, then they're within the statute. If they don't, then it's expired. They can't sue you, and if they do, you can file a motion to dismiss, saying it's outside the statute of limitations. Now, it's important to know that's different than if a judgment has been entered. Once they sue you and get a judgment against you, each state has a different amount of time that civil judgments are valid. In Arizona, civil judgments are good for 10 years, and they can be renewed every 10 years for the rest of your life. So that statute, a lot of people have these old judgments and they're like, isn't it outside the statute yet? Unfortunately, at least in Arizona, no, it's 10. I've seen some states as short as 5. I've seen other states, the judgments can be good as long as 20, and other states like Arizona were 10, but they can be renewed over and over again. So let's see here. He's saying if they don't pay, can they still harass us? Oh, by the way, thank you for the super sticker. That's awesome. Thank you. So they can send letters. Technically, they could call. I don't see a lot of, other than letters. It's rare when I see people are getting a lot of phone calls on debt that's outside the statute. Again, the Fair Debt Collection Practices Act applies. And so if they ever misrepresent the nature of the debt and infer that they could sue you, send letters, call you on the phone, there's going to be a claim. Trying to collect on debt that's outside the statute of limitations is risky business for the creditor. And so you don't see a lot of it, but you might see a few letters here in hopes that you're just going to send that on over. All right. Adam says, if I avoid a process server, how long before they can have a judgment against me? Well, here's, I am a guy who goes against the grain here. I usually recommend not avoiding the process server, because you're going to end up with a default judgment against you, because eventually the court's going to allow them to either just leave it at your door, mail it to you, email it, post it in a newspaper, something like that. You won't see it, and then a default judgment will be entered against you. So, but if you avoid the process server, like in Arizona, from the day they file the lawsuit, they have 90 days to serve you. And if they don't serve you, the court should dismiss it. The court can extend that time, and they usually do, at least in Arizona. The creditor can come in and say, hey, I'm having a rough time finding Adam here. Can I get another 90 days? And the courts will usually give that to them. So, I mean, the clock to respond to the lawsuit does not start ticking until they actually serve you with it. But avoiding this process server, I usually see that be problematic. So you got to be careful with that. Rocky, we'll do one more with you. It says, why would MCM let her state that when it's not outside the statute, 6 years in Washington? And the reason why, this is one time when you got to trust the debt buyer. If they're stating that, you can use it against them. Okay. And the reason could be is because they're reading a statute that tells them that maybe there's that this might be outside the statute of limitations, and they're going to err on the side of caution on here. So for example, in Arizona, it states that the credit card accounts that there's a 6-year statute of limitations. But Arizona also has a law that says if there's a written contract that was entered into outside of the state of Arizona, the statute of limitations is 4 years. So it's a shorter time period. So like we see this like with student loans and things like that. Someone enters into a contract where they went to school, they sign the agreement there, they moved to Arizona. The law says it's a 4-year statute rather than the 6. So there may be other statutes in play here that at least the legal department at MCM is looking at and saying, we don't want to run afoul of the Fair Debt Collection Practices Act, so we're going to err on the side of saying this is outside the statute. Final thing is just keep that letter. That's going to be your ticket for having that thing out of your life for good. All right, everybody. Thanks for checking in today. Again, have a happy Labor Day. Go Cougs. Hope BYU does well this week. I hope your team does well this week. And we will catch you next week.